Well, I think we're going to get underway at this time. Good afternoon, everyone, and thank you for coming. Before I get into my very short remarks, I just want to tell people that and remind people of what a busy, vibrant place we are here at Widener Law, specifically the Harrisburg campus, with today's 7th annual John L. Gedid Lecture, proudly sponsored by the Wolters Kluwer Publishing Company and Widener University School of Law. But I also want to let people know that there is more going on this week as well. For example, on tomorrow, most of the day, 9 to 5, we have a symposium entitled Perspectives on Mass Tort Litigation. And that particular symposium is being handled by the Widener Law Journal and Professor Christopher Robinette, who joins us here today. Been looking forward to that event for quite some time. And then on Thursday of this week, April 18th, from 4 to 5 p.m., our visiting scholar, Donald A. Brown, will be talking about how U.S. domestic climate law needs to respond to emerging international climate law. So stay tuned. You are welcome to come back. We'd love to have you at any time. But tonight's series is a named series, and it honors Professor John L. Gedid, the director of Widener Law and Government Institute and one of the founders of the Widener Harrisburg campus. I just asked him, I said, John, what year is this for you? This is the end of my 7th year. And he says 25 years. That's quite a milestone to do anything. So we give him a round of applause just for that. John served as the Harrisburg campus's first vice dean, and since that time has been a campus leader in his various roles as teacher, scholar, and mentor to students and faculty alike. And for those of you who do not know, John will be transitioning at the end of this year. He can legitimately put the sign up that says "Gone Fishing" because he's going to retire. I can't begin to tell you what a wonderful role model John has been. And for those of you who know him, you know that I'm not telling you anything that is new or different. But just in case there are some of you sitting out there this afternoon who don't know John, I've known John for a number of years. I'm not going to tell you how many because I want you to think that John is considerably older than I am. But throughout my years of knowing John, I've always known him to be the kind of person who is excited, who has been excited about learning, about mentoring young people. And I can tell you, for those of you who are students here and alums, not only has he spent these 25 years mentoring people here, but I often run into some of his former students who were at Duquesne when he was there. I don't know how many years you were there before he came here. Is that right? And so he is, I don't know whether he has perfected the aspects of mentoring that we all try to perfect, but I can certainly say he's been in the trenches for some time, and typically people find me to tell me, you know, I had John Gedid as my professor, and I always, I guess, automatically smile because I know that whatever they're going to say, it's going to be something good. And we are all better off as a result of it, not only here at Widener, not only in Central PA, but as our grads go everywhere. And so if you've sat under the tutelage in some respect of John Gedid, you have been fortunate to do so. This particular series is in recognition of his commitment to legal education and the intellectual growth of Widener's students and faculty. The series showcases the innovative work of nationally recognized scholars on a broad range of legal topics, and usually they are scholars who are on their way up. With that said, Again, I welcome you to this particular lecture series, and Professor Michael Domino will now tell you more about today's speaker. Thank you for coming.
Thank you, Dean. Thank you, ladies and gentlemen. Welcome to the lecture. It is my primary duty in giving this little introduction to give some thanks to people whose efforts contributed to the lecture generally and to today's lecture. Start off first by thanking Aspen Publishers. Aspen, since the institution of this lecture series some 7 years ago, has been very generous in its support of this series and has been very generous in providing an honorarium for our speakers. There is one thing, not so much a criticism or a complaint, but merely an observation. Aspen, as I say, has been very generous in providing an honorarium for our named lecturers. It has been considerably less generous in providing an honorarium for the people who do the introductions of the speakers. But we thank Aspen for all of its help over the last 7 years. In addition, Sandy Gray, the Secretary for the Law and Government Institute, has been instrumental in putting together this lecture, as she has been instrumental in putting together all of the previous lectures. She has been on top of organizing the logistics of the event and making sure that neither I nor anyone else manages to forget something important about how to put on this event. So thank you also to Sam. And now to thank the man, to paraphrase Yogi Berra, who has made this day necessary. The lecture series, as Dean Ammons remarked, honors John Gedid. The lecture series features the scholarship of young, up-and-coming scholars, generally in the public law realm. And the reason that it does so is because John has been such an inspiration, both to students here and to young faculty members on this campus. As one of those faculty members who has benefited from John's advice, John's kindness, and even generally John's presence on this campus, I wish to extend my thank you to John for all of his efforts here since I've been here and for a considerable number of years before that. And it's entirely fitting that we have this lecture series in his honor. Now, we have a tradition of presenting John with this folio that includes the flyers that advertise each of the lectures year to year, complete with signatures and nice messages of each of the speakers. Professor Kerr has been kind enough to continue in that tradition, and so today we present John with the folio again with another page in it that honors both him and today's speaker. So John, would you come up here and receive this folio? Thank you. And now the final thank you is to our speaker. Orin Kerr is the Fred Stevenson Research Professor of Law at the George Washington University School of Law. He is a former clerk on the Third Circuit and then on the United States Supreme Court, Justice Anthony Kennedy. He has himself argued cases before the U.S. Supreme Court. He is a co-author of the leading criminal procedure casebook, and he is the sole author of a casebook on computer crime law that's now in its 3rd edition. He is a remarkable scholar, and he's a remarkable human being. It is my pleasure to say that I have known Orin personally, and I found him to be a very kind, very generous man. He's always been willing to speak to me when I've had questions about criminal law or criminal procedure, want to bat around ideas. He's always made himself available, and he makes himself available to all of us today in speaking about the need for a new Electronic Privacy Act. Please join me in thanking Orin Kerr.
Well, that was really good. I think we should just keep listening to that. I kind of like that talk. Thank you all for coming. Thank you to Michael for the introduction, for John for having the series, and for Dean Ammons for the introduction as well. I wanted to talk this afternoon about a forthcoming paper of mine. I sent in the draft of it in March. It's going to be coming out probably in about a year. But I have not ever presented this subject before. So this is the first audience to hear of a set of ideas that I've been working on for the last few months. And it's about the area of the statutory privacy laws. These are the privacy laws that regulate access to your email, that regulate internet wiretapping, that regulate the records that are generated and stored whenever you use the internet or telephone networks or any kind of computer network. The issue is how to really deal with the relationship between, on one hand, the government that might want access to your communications or your records, and service providers, the companies that have access to those records and those contents of communications. What makes network surveillance different from physical surveillance is that there is this intermediary of the provider. When the government wants to monitor somebody in the physical world, just watching somebody on a street, for example, they do it all directly. They walk down the street, they see somebody. If they want to execute a search, they enter the home to execute the search. They do it all themselves. In the network environment, all of our communications, all of our actions are mediated by providers. I'm sure you're familiar with some of these providers, names such as Google or Facebook. These are all companies that are just examples of one of many companies that have access to your information, are the companies that you use when you're communicating with somebody online. And ultimately, the question that I want to talk about today is what should the rules be, and what are the rules governing access to that information when the government wants to get access through those service providers, through those internet companies, to your private information, whether it's a message that you sent or records as to how you used a particular service or anything in between. And in particular, I want to argue that the set of privacy laws that exists today, a set of privacy laws known as the Electronic Communications Privacy Act, or ECPA for short, is horribly outdated. This goes back to a 1986 set of laws that enacted ECPA, that enacted this framework. And it has actually become a little bit of a cliche over the last year or two to just say the law is outdated, and it's an easy target, right? To say that a law from 1986 that involves technology is outdated, that's kind of easy to say. But I want to make a different argument than what anybody else is making. What a lot of people are saying is that the standards in the privacy laws need to be enhanced. There needs to be greater protection, recognizing the greater role of the internet and computers in society today than in 1986. Okay, I basically agree with that. That's fine. But that approach retains the existing law and just fiddles with some of the standards. It basically takes the framework that was adopted in the 1980s and just tries to raise privacy within that framework. And I'm going to argue a different position. I'm going to say that the entire structure should be rewritten, the existing statute should be repealed, and a new statute should be enacted that recognizes the reality of today's computer networks. And I'm going to rely primarily on two different ideas. These are two aspects of how computers work and how the internet works, which are how today's network works, how today's technology works. And it's the kind of thing that is not obvious to a user. One of the interesting aspects of using computers and the internet is we, the users, interact with browsers or interact with the machines, focusing on the way the software presents itself to us. But there's a lot of stuff happening behind the scenes. And a lot of times what happens behind the scenes is much more important than what we observe. And I'm going to argue that there are two differences between how the internet works today and how it's worked in the past that require a change in how those privacy laws work. And there's things that go on behind the scenes but are incredibly important to understanding privacy laws. And there are two basic ideas that I'll introduce and then I'll come back to later on. The first idea is that storage has become incredibly cheap. In the 1980s, storage was expensive, and when we thought about electronic privacy, we weren't very worried about privacy in stored communications, because storage was so expensive there just wasn't much stuff that was stored. Today, the opposite is true. Storage has become incredibly cheap, astonishingly cheap. So much that we've entered a world and increasingly are going in the direction of a world of total storage of electronic communications just because it's so cheap to do that. So that's one major shift, and I'm going to argue that that shift from expensive storage to cheap storage has dramatically changed the nature of the privacy threat, and therefore dramatically changes the nature of the laws that we need to respond to it. So that's argument number one. And the other argument is about territoriality of communication. So in the 1980s, using computers, using networks, was almost exclusively a domestic concern. Most internet communications were inside the United States. If you were inside the United States and you were sort of at the vanguard and were sending email, for example, that email was very likely staying inside the United States. And people outside the United States were likely not using US-based computer services. That's no longer true. We've now entered a world in which communications have become global. US-based companies with US-based services are often serving a primarily foreign audience. Their user base is not in the United States, even though the company is in the United States. And that raises important questions of choice of law. How do you deal with the privacy rights of somebody in the US who is using services outside the US, or somebody outside the US who is using services based inside the US? What governs? Is it the location of the person, the location of the server, the location of the company? Is there some sort of global internet practice that goes beyond sovereignty? How do we deal with the fact that the modern network is one that just, it not only is storage incredibly cheap, but the way the network works just allows global storage. Information can be anywhere. And I'm going to argue that those two changes cause a need for a restructuring of the electronic privacy laws. Okay, so in order to make my argument, I need to tell you a little bit about the current privacy laws, because it's not going to work for me to just say we need change if you don't know where we are now. So let me talk about the history of the privacy laws, starting with the 1968 Wiretap Act, and then moving to the 1986 Electronic Communications Privacy Act, which amended the Wiretap Act. So the Wiretap Act, enacted in 1968, is the first sort of carefully thought out wiretapping statute enacted in the federal law, dealing primarily with two kinds of technology. One, bugging devices, audio recording devices, and two, interception of telephone calls using wiretapping devices. And I'm going to ignore the bugging aspect of it because that sort of stays constant while the rest of the technology changes in interesting ways. So the 1968 Wiretap Act was the parts that are focused on telephone interception basically said, okay, let's model the world of privacy involving telephone calls by imagining two people on a phone call and some third party that's trying to go in and listen in on that communication. You can sort of imagine, a string with two sides, and someone grabs in there and listens in. They get their wiretapping device and they listen in on that call. And the prohibition in the statute was intercepting the oral communication of a party, those people on the two sides, without the consent of at least one of the two parties. That was what's prohibited under the Wiretap Act. And then the statute says that if the government wants to engage in wiretapping, they can get a very special court order, not just a search warrant, not just a warrant based on probable cause, but a special kind of super search warrant that's very hard for the government to get. They have to show, for example, that they tried other methods to intercept the communication or to obtain the information. They couldn't. They have to go through all sorts of administrative hurdles, very difficult order to get. But the idea was that invading the privacy of two people on a telephone call was a really serious privacy threat, and that power of the government had to be carefully cabined. And the monitoring had to be of the human voice. The oral communication, the wire communication of the telephone call had to include the human voice. So listening on people talking on the phone was what the 1968 Act prohibited. So that's the 1968 Act. And by the mid-1980s, Congress realizes that that act has become somewhat outdated. And to my mind, this is somewhat remarkable. In 1986, Congress enacts a new law amending the 68 Act to respond to the new world of computers and email at a time when most people had never heard of email. So this is kind of a remarkable idea. We think of Congress lagging behind technology. There's no way that Congress can keep up. This is Congress enacting a new law in 86. Most people start using email sort of like maybe, I don't know, 93, 94, 95. So this is years beforehand. Congress had dealt with this problem of what to do with email privacy. And it was really prompted by a 1985 Office of Technology Assessment report, Civil Liberties in the Digital Age, or I think that was the title, something like that, Civil Liberties and Privacy or something like that, dealing with the problems with the Wiretap Act. And here were the problems that the Office of Technology Assessment had identified. They said, we've got these new world of computer networks, and a lot of people are using, or a few people, more and more people, are using these computers to communicate with each other, and they're not making phone calls when they're communicating with each other. The Wiretap Act does not apply. Why doesn't the Wiretap Act apply? Well, there were two reasons why the old privacy laws didn't address the problem of email and these sort of new computer networks. The first problem was that the Wiretap Act only applied to interception that covered the human voice. And when you're sending an email or something, of course, the human voice is not normally involved. It's just text. So the Wiretap Act did not apply. That was one simple reason. And the other reason was that the Wiretap Act presupposed a real-time communication, an ongoing communication that the wiretapper was collecting kind of in transit. You sort of imagine the communication between A and B and C, the wiretapper is listening in. It is an ongoing communication. The communication is in transit from A to B, and C is listening in. And that was not necessarily the problem with emails. That was one problem with email privacy. But emails could also be stored. And once they were stored, they were no longer protected by the Wiretap Act, because for technical reasons, the Wiretap Act only dealt with this kind of real-time interception during a transfer of the communication. And when the communication was stored, it was no longer being transferred, and therefore the old law didn't apply. So Congress says, okay, let's enact a new law. They enact this new law, the Electronic Communications Privacy Act. And in 1986, in its original form, it has three different parts. The first part is to take the old telephone wiretap statute and say it also applies to computer communications. Any interception of the contents of a communication, like real-time interception of an email, is covered under the Wiretap Act. So basically, they took the framework from the telephone, added in computers to the category of protected communications, and that was it. That was sort of the first part of this. The second part they added was a new privacy law called the Pen Register Statute, to deal with protection primarily in the telephone context for numbers dialed other than the contents of communication. So the Wiretap Act had originally dealt with the call being intercepted, but the Supreme Court had held in a case, Smith versus Maryland, a few years earlier, that the numbers dialed, the sort of non-content information about the call, was not entitled to any Fourth Amendment protection. So Congress in 1986 adds this statute, the Pen Register Statute, to say, okay, you're not allowed to conduct monitoring of what numbers people are dialing, kind of caller ID information without their consent, without the government getting some sort of court order or the phone company having some reason for business reasons to collect this information. And then the third statute they enacted was one really dealing with stored communications, which sometimes gets called the Stored Communications Act. Stored Communications Act, very complicated, but it basically broke down the privacy world of stored communications into two different parts. The first part was email, what the Congress called providers of electronic communication service. That is kind of people that are, companies that are providing services that give you connectivity, that are letting you message with other people. That was the first category. And then the second category Congress talked about was providers of remote computing service, which we know of today as kind of cloud services. These are services where you outsource something to a remote service provider because you can't do it locally or you don't want to do it locally on your own machine. Now, in 1986, the idea of a remote computing service, this sort of cloud service, was only available to companies, not to individuals. And it was primarily for businesses who, for example, might need number crunching for their payroll software. There were no spreadsheet programs available yet, so if you want to do number crunching on your payroll, you needed to send it out to a company that would do the operations on the data set and then send it back to you. And Congress said, we're worried about two different kinds of stored communications. We're worried about these sort of emails that are stored, and then we're worried about things that are in the cloud. That was the two basic sort of categories. At the same time, the level of privacy protection that Congress gave was quite low. So this is 1986. Very few people are dealing with these kind of new communications. And Congress said, well, you know, we're dealing with mere computer communications. It's not like we're dealing with personal phone calls. So we don't want to give that much privacy to these mere computer communications. We'll say that email gets the protection of a warrant when it's stored with a service provider for 180 days. And after that, well, if you don't read your email in 180 days, you've abandoned it. No one's going to store email for that long. And when you store things in the cloud, well, that's kind of like giving it to your accountant. It's almost like giving up your privacy rights in it. So even though it's held by this third-party service provider, the government can get access to it quite easily with a mere subpoena not requiring probable cause rather than a search warrant that would require a probable cause. So the basic idea was to say, we're going to give privacy protections to these new kind of services, focus primarily on the telephone analogy for real-time acquisition of information, and then have lesser amounts of privacy for stored communications. That's the basic structure of the 1986 law, which has been updated from time to time. For example, in 2001, as part of the Patriot Act, the pen register statute, which was really focused on the telephone, was expanded to apply not only to the telephone, but also to non-content internet communications. So we have a low degree of privacy protection under current law for non-content information, relatively a very high degree of privacy protection for contents of communications intercepted in real time, and then low privacy protections for stored content. That's the basic structure of current law. Now, as I said earlier, everybody criticizes the current structure as being outdated. A lot of sort of the New York Times editorial page has weighed in that this is outdated. And if they say it, then everybody's saying it, at least if it's not a political question. So a lot of folks are saying that the law is outdated. But the key to sort of understand my ideas is that the nature of the criticisms that are made of the statute are very narrow. And I want to focus on proposals by a particular coalition that's, they call themselves the Digital Due Process Coalition. And this is a group of companies and civil liberties groups and private individuals that got together to agree on a set of proposed reforms to the current privacy laws. And when I say companies, I'm including Google, Facebook, Amazon, Microsoft, civil liberties groups, including the ACLU, the Electronic Frontier Foundation. This is sort of the major internet companies and the major privacy groups kind of got together, and they came up with a set of proposals that they said should be used to amend the statute. If you look at the proposals of the Digital Due Process Coalition, almost all of the proposals are about raising standards for privacy. They accept the current framework of the law. They accept that real-time communications are treated differently than stored communications. They accept the current distinction between electronic communication service providers and remote computing services. They accept the structure of the breakdown from the Wiretap Act to the Stored Communications Act to the Pen Register. What they argue for is just greater protection. So, for example, they say that there should be a full warrant protection for all stored contents, regardless of whether it's held by an electronic communication service or a remote computing service. But it's still, you have to satisfy one of those two categories in order to receive any protection at all. They argue, for example, that there should be a raised standard under the Pen Register statute for the government to obtain non-content information about telephone calls or emails. For example, let's say the government wants to know what email addresses a particular person is emailing. They can get that list using the Pen Register statute, and all they have to do is tell the government that we certify that the information to be obtained is believed to be relevant and material to an ongoing investigation. They don't actually need to show proof of that. They just certify that that's the case. and the Digital Due Process Coalition, as many people have before it, including myself, argue that that standard should be raised at least to the level of kind of what in Fourth Amendment law we would think of as a Terry stop standard, reasonable suspicion that you have to show to the judge justifying the release of the records. But basically all of the concerns and all of the proposals that have been made are about raising standards. What I want to argue is that actually the technology has changed so much that we don't need to raise standards. We need to abolish the existing statute and start with something very different. So let me talk about the ways in which the technology has changed. So as I mentioned earlier, in 1986, storage was really expensive. And as a result, Congress wasn't terribly worried about stored communications. You can see that in the Stored Communications Act, this idea that email should be protected for 180 days. Why not more than 180 days? Well, because people just weren't going to store for 180 days. That storage was expensive. Why would you store files for that long? Probably if you store them for that long, you were never going to look at them. You'd effectively abandoned your email. That was the assumption of 1986. The assumption today is the exact opposite. Storage has become incredibly cheap, and therefore we've entered a world of virtually sort of total storage. And let me give you a couple numbers to back that up. So a computer science professor at UCLA calculated the typical cost of storing 1 gigabyte of information remotely. In 1984, the storage of 1 gigabyte of information was about $85,000. In 2011, when the study was conducted, the storage cost had gone from $85,000 to 5 cents, dropping about a factor of 10 every 4 years. And you see this, you saw this in part, you may remember in sort of mid to late 1980s when people started to use web-based email services like Hotmail. It was sort of amazing. Somebody was giving you a free storage account and you could use the email service. That originally was a big deal. It came with 2 megabytes of storage in the late 1990s. Today's Gmail account comes with 10 gigabytes, which is 5,000 times more storage than was common in these accounts in the late 1990s. Again, you as the user don't really notice. You may just notice that you never seem to run out of space in your account. More and more emails come in, and you probably don't delete them. I know in my case, I don't bother to delete emails. It could be an irrelevant email. I know it's irrelevant. I'm just going to leave it there. Why bother going through the time of deleting emails when there's sort of infinite amounts of storage? And it turns out that the typical Gmail account has approximately 17,000 emails in it, on which on average that's 12,000 emails in the inbox and about 6,000 to 7,000 outgoing emails that are stored of the outbox or the copies stored on the way out. That's 17,000 emails. That's a lot of emails relative to a world of 20 years ago, 30 years ago, where there'd be very few because storage was so expensive. And not only are people now storing all their communications online, not bothering to delete their communications because storage is so cheap, but service providers now are keeping records of everything in a way that they couldn't do before. And an example of this became clear a few years ago in a case involving what's been known as the Craigslist killer. During this investigation, which occurred in Boston, Facebook released pursuant to a court order, Facebook released the contents of the suspect's Facebook account. The entire contents were ultimately released by the Boston Police Department. And it turns out the Facebook account by the suspect was not very widely used, but it recorded everything the Facebook account did. And I don't just mean every message that was sent or every picture that was posted. I mean every picture that was posted and then was then deleted, every friendship connection, every status updates that were subsequently deleted, also still stored by Facebook. Not only that, Facebook kept a record of every page that was clicked by every customer. Now, as many people know, Facebook widely used to stalk ex-girlfriends and ex-boyfriends, check up on old high school friends, see what people are up to. And there's a joke virus email that goes around that Facebook suddenly is now recording every click you've made. And now other people can see if you're looking at their Facebook page. And it scares people when they learn of this. And it's all just a joke. You can check out Snopes.com. It's not real. But actually, Facebook keeps all of that information. It's not that they need it. It's not that they use it very often. It's just that they can. Storage is so inexpensive that recording all of the clicks of every user of every page, every picture, every status update, everything is easy because storage has become so inexpensive. Now, what has happened, I argue, is that because storage has become so cheap, real-time monitoring, which was the major concern of the Wiretap Act and the major concern in 1986 as they applied the Wiretap Act to computers, that is no longer the primary privacy threat. Because instead, in a world where very few things are stored, real-time surveillance is what's sensitive, because that's where the data is. So the government is going to engage in real-time surveillance. They can try to get access to stored records, but there aren't that many records to gain access to that are stored. In a world of total storage, all the records are there in stored form, so they don't have to engage in real-time wiretapping anymore. And if you want to see an example of this, the Wiretap Act requires that state governments and the federal government report on the number of wiretap orders that they obtain every year. And they have to give some detailed information, including whether it's a wiretap for telephone calls, a wiretap for computer communications, or both. And if you look at the number of wiretap orders obtained in the United States for just electronic communications, can anybody guess? Let's just say the federal government. How many wiretap orders does the federal government get on an annual basis to wiretap email accounts? This is a country of more than 300 million people. The answer in 2012 was one. State governments added another 3. And it's not that the governments are saying we don't need access to the internet. There's no evidence on the internet. It's that they're gaining access to stored communications instead of real-time communications because all the information is still there available in stored form under lower privacy protections than for real-time communications. Wiretap orders are very difficult for the government to get, so the investigators rationally respond by saying, let's just never get them. We can get all that information through access to stored communications instead. So that prompts the natural question of how often is the government getting access to stored communications? The numbers here are harder to obtain because there's no national reporting requirement. However, Google has released a transparency report in recent years. And in 2012, sort of putting together the numbers of how often they've been served search warrants for the contents of Gmail accounts. This is just one service provider. The number was about 4,000. And so if you figure that's just Gmail accounts, there are lots of other accounts, you're talking, I don't know, maybe 20, 30,000, it's just a rough ballpark estimate, of the number of search warrants served on service providers for email accounts as compared to one wiretap order for the entire federal government and another 3 for all of the state governments in that same year. So what's happened is total storage has shifted the privacy threat. Gaining access to real-time communications today is actually gaining access to only a narrow sliver of the kind of records that are available when the government wants to get access to stored communications. Through gaining access to the stored communications, they get access to all 17,000 communications that are in the person's email inbox. It's the stored access which is the real threat today. Another problem that raises is that the 1986 statute, since it presupposed that not that many records would be available, had no limitations on particularity or minimization in terms of gaining access to account records. So let me give you talk a little bit about what that means. Whenever the government gets a court order to gain access to records or contents, there's the question of, first, the threshold they have to satisfy. Is it probable cause, reasonable suspicion, something else? And then once you satisfy the threshold, the question is how many records can they obtain under that one court order? And that's a question which in Fourth Amendment world is known as particularity. How specific are they being as to which records they want, and how specific are they being as to where they're going, which records they're getting? In other words, how broad is the search that results after the court order is obtained? The 1986 statute says nothing about this question. They did not care about particularity. They talked about gaining access to account records. And once the government satisfied the threshold, all account records could be disclosed. Not only is there no discussion of how narrow a group of account records can be obtained, there's no discussion of how many accounts can be obtained. And so in a case in the mid-1990s involving a search warrant to obtain access to, at the time, American Online accounts, the government obtained a single search warrant to obtain the entire email accounts of, I think it was 76 different accounts. And the defendant said, well, this is overbroad. This is an overly broad search. And the court said, it's only 76 accounts. That's not overbroad. And today we think, well, wait a minute. If one account has 17,000 emails, think how broad a search it would be to obtain 76 accounts. The scale has become dramatically different, and the statute does not currently speak to the question of scale. Another example that I wanted to flag is a technology known as the cell tower dump. And so to explain this is a very helpful example, I think, you need to know a little bit about how cell phones work. Those of you that carry cell phones all day are carrying a location tracker in many ways, because the device does not work by magic. It works by communicating with local cell towers, which route the communication to you and from you whenever you want to place a call or receive a call. And that means that the phone company is generating records as to where you are located, because that tells the phone company where they can route your call. So if a call comes into you, let's say you have AT&T as a provider, AT&T needs to know where you are. If today I'm in Harrisburg, Pennsylvania, tomorrow morning or tonight I will be in Washington, D.C., they need to know where I am in order to route the call. So whenever the phone is on, it's constantly sending out signals saying, hey, local towers, I'm over here. And when you look at your phone and it gives you the number of bars on the phone, what that's saying is how direct a connection is your phone connecting with the local cell tower. And when you're driving and it drops the call, that means that one cell tower has relinquished the call, another one was supposed to pick it up, and it didn't pick it up, so it dropped the call while you were driving. So what this means is that there are records indicating where you're located that the cell phone companies have that the government might want to use. And where this has become particularly important is in real-world crimes involving burglaries or sexual assaults or homicides, where the government wants to know who was in the area at the time of the event. So let's say we know that a particular store was burglarized at a particular time. The government might say, okay, well, we want to know whose phones are local. And you think, well, how's that going to be helpful? That effectively gives the government a list of possible suspects. And you can imagine that there's not just one, let's make it a bank robbery. There's not just one bank robbery. There's a string of bank robberies. And the government wants to know what telephones are in common that happen to be near each of the banks that were robbed at each of the different times. Think about that. Let's say there's a list of 10 people that happen to be in the right place or the wrong place at exactly that time over a series of events. Well, that's going to be really helpful evidence to narrow down a list of possible suspects. So from the government standpoint, they refer to this as a cell tower dump. It's basically give us the information of all of the phones that were near the event within a particular time window. But here's the trick. There's no necessary correct answer as to how broad that court order has to be. So let's say the government says, well, we want to know who was in the immediate area within 5 minutes of the crime occurring. Let's say another officer says, well, maybe they cased the joint before they went in, and they turned off their cell phones before they went in. How about anyone that was within 2 miles of the event for a 3-hour period? And suddenly they're no longer talking a single tower. They could be talking about records relating to thousands and thousands of people over a long window of time and a wide distance. So suddenly the government is getting lots and lots of records. The current statute says absolutely nothing about this problem. It says nothing about how to limit the scope of the court order that the government can get. So the second major category of technological change that I want to talk about is territoriality of communications. As I mentioned earlier, in the 1980s, when Congress was drafting these statutes, everyone, pretty much if you were using computer networks in the United States, you were in the United States communicating with United States-based services. It would be rare to communicate with a service outside the United States, and service providers in the U.S. were serving a domestic audience. That's no longer true, and some of these statistics I want to throw at you I think are really revealing. Facebook, which has servers in the United States, a majority of Facebook users worldwide are not in the United States. In fact, only 16% of Facebook users are inside the United States. The overwhelming majority of Facebook users are outside the United States. Why is that? Well, Facebook has basically saturated the entire United States. I think it's 54% of adults in the United States have a Facebook account. And so it makes sense that as a global service, since the U.S. is only a small part of the global population, that for these global internet services, most of the customer base would be located outside the United States, and that's true with Facebook. Gmail is another example. In the case of Gmail, again, servers in the United States, in California, 29% of Gmail users are inside the United States. More than 70% are outside the United States. In fact, Gmail, it turns out, is the most popular internet service provider or email provider in India. So these are services that are the U.S. companies. They have their servers in the United States, but most of their users are coming from abroad. And why does that matter? Well, it creates a lot of difficult questions for foreign law enforcement and for companies and for U.S. law enforcement cooperating with foreign law enforcement. So imagine a crime that occurs in India. Someone in India sends an email threat to somebody else in India, and it is they use their Gmail accounts, as many people are in India. Well, suddenly the evidence for that crime is in California. And if you are a law enforcement officer in India, you need to collect your evidence in California. Well, the current privacy laws enacted in the 1980s just have no answer for any of these questions of how you deal with crossing jurisdictional lines, because it just wasn't a problem that they thought about at the time. It wasn't a realistic problem given the technology of the day. At the time, they didn't say anything about the territoriality of the statutes, and the courts have filled in the default rule in United States law, which is that it's assumed that these laws apply only inside the United States. So for the Wiretap Act, for example, wiretaps are only illegal under the U.S. wiretapping law if the taps, if the actual sort of place of interception, is inside the United States. Well, fine in the case of wiretaps, but how does that apply to stored communications that are not really necessarily in a place? So in the old days, you'd have one server for the company, and all the email would be located in that server. Today, with companies like Google and their Gmail service or Facebook, they have farms of various servers, and sometimes the information can be located in different places at the same time. So for example, it might be that you have an email and an attachment. You don't know this, but the email is in one place and the attachment is in another place, and the company has to combine them in order to send them. And for network reasons, it may be easier to have servers that are in different countries rather than in the same country. And it could be that sending an email, that where is the email located? The answer could be parts of it are in one country, parts of it are in another country. How do you deal with a law that only regulates disclosure inside the United States? What does that even mean? And also a problem with companies that serve all around the world. For example, there was a recent, in 2007, Yahoo was indicted in Belgium for failure to comply with a court order in Belgium to disclose the contents of communications. Belgium, the Yahoo authority said, I'm sorry, we're unable to disclose to you guys because we are covered by the U.S. privacy laws. The information is in the United States, and under U.S. privacy laws, we're not allowed to disclose without a United States court order. And the Belgian authority said, well, under Belgian law, you have to disclose, so we are going to charge you with a crime in Belgium. This is a case that's still ongoing, and it's caused by this clash between the laws in Belgium and the laws in the United States. Under the current legal regime in the United States, it's sort of a random set of rules. The providers are not allowed to disclose inside the United States, except if there's a US-based court order. They're allowed voluntarily to disclose non-content information to foreign governments, but only because they don't count as governments under US privacy law. So the US privacy law said if it's non-content records, providers are allowed to disclose non-content records without a court order. Why? Well, because they might want to use those records for telemarketing purposes or to sell their database or something like that. It could be a customer database. They want to use it for advertising. So they're allowed to disclose to non-government entities, which it turns out happens to be included in the category of foreign governments or non-government entities under the statute. So the U.S. companies currently say we can disclose the non-content information. We're not allowed to disclose the content information. But there's also a wrinkle, and this is a wrinkle that the courts have not dealt with. If you're a multinational corporation, what happens if you just quietly bring the data outside the United States to one of your subsidiaries outside the United States? Well, at that point, the privacy law doesn't apply. Does that mean you can then disclose once the information's outside the United States? Or is there some requirement that since the data originated in the United States, you have to keep it in the United States and merely bringing it outside the United States is not allowed under the privacy laws? Just problems that the drafters of the 1986 law didn't think about because it was unthinkable based on the technology of the day. And now are major problems that providers deal with all the time. Okay. So these are the problems. This is why I think the statute is currently outdated, needs sort of dramatic restructuring. So how would I restructure it? So let me talk a little bit about some answers that I propose. So the first thing I would do is abolish the distinction between having a Wiretap Act that covers real-time communications access and a Stored Communications Act that deals with access to stored communications. I would treat them all in the same way. I would abolish the distinctions between remote computing service and electronic communication service and just have a straightforward rule that at the court order stage, the government is required to obtain the same court order, and I think a traditional search warrant is the right standard, to gain access to contents of communications, regardless of whether it's real-time or stored, regardless of whether it fits sort of these 1986 antiquated categories. So I would have a uniform warrant standard in all of these different categories, recognizing that the line between stored and real-time just no longer makes any sense. So that's one answer. Then on the question of what I would do for the particularity problem, what do you do with the cell tower dump, where it could be thousands of people's of records? Or what do you do with the fact that there are 17,000 emails disclosed in a typical warrant for a Gmail account? So I think there are two different answers. One would be in the content context. Courts have begun to recognize Fourth Amendment protections for stored contents of communications. Right now, we've seen one circuit court decision from the United States Court of Appeals for the Sixth Circuit, which has said that remotely stored contents, in that case it was a Yahoo email account, are protected by the full warrant requirement. If other courts agree with that, if the Supreme Court agrees with that, which I think that they should, then it may be that the question of access to stored contents, the actual messages of communications, are actually covered by the Fourth Amendment rule, and we don't need the statutes to address that question. It may be that the Fourth Amendment covers the ground, and so the statute is unnecessary. But so far, the courts have indicated that the non-content records, the records of IP addresses somebody might have used, records of who somebody emailed, is not protected under the Fourth Amendment. So that raises the question of how do you determine the degree of particularity of a court order once a court order is obtained. And the idea I have for this is to recognize what I call an approach of customer hours. Here's the problem. If an individual user can have accounts that last, that they're using for a long period of time, and you have, in the context of cell tower dumps, many users with records that are available over a short period of time, I think a way of potentially trying to address the particularity of these various court orders is to say that the different court orders can be obtained for different customer hour limits. So for example, let's say, just to pick an arbitrary limit, in the case of cell phone location information, you could have a rule where if the government obtains a court order showing that that information is going to be relevant material to an ongoing investigation, that they can either obtain one customer's information for a certain period of time, say 500 hours, let's just pick a number, one person's communications for 500 hours, or they can get, say, 2 people's records for 250 hours, or 5 people's records for 100 hours, or in the context of a cell tower dump, they could get 500 people's records for 1 hour, basically saying there's a trade-off that the government has to deal with between the number of people whose records are obtained and the amount of time over which the records cover. I think that's one way of trying to cabin the scope of records and try to identify what's the proper level of particularity of communications. So once the government has satisfied its uniform threshold, if the Fourth Amendment is not imposing a particularity requirement, if the Fourth Amendment is not triggered, then the statute, I think, should limit the scope of the order based on the overall number of customer hours obtained per order. Finally, my idea for how to deal with the question of territoriality. So I think I would break down the problem of territoriality into 2 different sets of rules. And in both cases, the idea that I think drives my proposal is that, at least based on current technologies, there are relatively accurate ways of knowing where somebody is located, at least in terms of whether they're located inside the United States or outside the United States. So, for example, based on the IP addresses that a person might use to access a particular site, the IP address they use to register for an account that they're regularly using to gain access to the account, you can often determine what country they're located in based on that information. It's not perfect. And if you really said, I'm going to make an effort to try to persuade, for example, Gmail, that I'm actually located in France, not located in the US, you could absolutely do that. But by and large, the companies know where people are located. And you could have a presumption that, for example, somebody with a certain amount of electronic connection to the US is inside the US. You can sort of set up rules to try to identify when people are sort of thought to be in different countries. And what I would do is have the privacy protection depend on the location of the person, not the location of the company or the location of the server, the location of the data. I would say that the rule should be to follow the location of the person, whether they're inside the United States or they're outside the United States. So my approach would be to say, if somebody's inside the United States, they should receive the protection of US privacy law, regardless of whether it's foreign authorities that are interested in the information or US authorities that are interested in the information. The level of privacy protection should be the same. And there should be the same required court order format that the current statute adopts. On the other hand, in the case of users of United States-based internet services that are located abroad, I would have a permissive regime both with respect to contents of communications and non-content information. So if somebody is known or believed to be located outside the United States, you could say that the providers are allowed to comply with foreign court orders of the country of wherever the person is located. If the provider decides that they would like to comply, they're allowed to comply. Now, one question is, why not require providers to comply with foreign court orders? And here the simple answer is we don't necessarily trust the foreign governments. So there may be some foreign governments that have democratic regimes and are genuine court orders and sort of a working criminal justice system so that we trust the court orders that are obtained. But there are other countries where that's simply not the case. So we would not want a standard where any foreign government, including rogue regime, some government we don't trust, can just come up with a fake court order and then the US companies are required to disclose. We wouldn't want that. But by making it a permissive regime, it's up to each service provider, it's up to each, it's up to Google, it's up to Facebook to decide which foreign governments' court orders they will comply with, which they're already doing right now in the non-content context. It's just that I would say that the same rule should apply to the content context. And I think that will then come up with a set of principles to govern the territoriality of privacy rights, essentially saying if you're in the United States, you get the benefit of U.S. law. If you're somebody who's outside the United States, you have no connection to the United States, you don't get the benefit of U.S. laws, except to the extent that the U.S. companies are going to require legitimate foreign legal process in order to give up the communications and the information that you have generated and stored with those U.S. companies. My sense is at least that's, if that's not the best answer, it's maybe the best of the least bad of the various answers to dealing with the reality of the modern computer networks. We've just entered a world of total storage and global storage, and the privacy problems that we face today are just very different from the ones recognized in the 1986 Act. Okay, so that is my presentation. Thank you for listening.
Maybe a minute or two for questions. Are there questions?
Yes, questions, go ahead. Yeah, great question. So there are two answers. One is you could have a rule where if they have any U.S. connections or a certain percentage of U.S. connections, they're treated as being in the U.S. And another is that this is a problem that the providers must be dealing with already, because I'm sure in the national security level, they're dealing with the issue of which contacts are from the U.S. people and which contacts are not from U.S. people. So the three-letter agencies must have worked out some sort of protocol on this question. So whatever it is, which we don't know. You're absolutely right, though. There's not a clear line. But you could have a presumption somebody's presumed to be in the U.S. unless proven otherwise or something like that. Yeah, there's one other question.
I guess my question would be, in terms of how you state like information being abandoned, do you ever reach that subject? Like, you know, if you had like an email that's like 5 years old and saved, would that be considered abandoned and actually accessible, or is that still, you know, under the privacy?
Well, under my approach, there would be no such thing as abandoning email. The reality is people store essentially indefinitely now, and you might decide to take information off the network for whatever reason, but people are storing information in the same way that people store stuff in their basement, right? And they're not abandoning it when they put it in their basement. They're just putting it away where they don't have to worry about it. And that's the reality of a world of total storage, is that a lot of people are going to do that.
Two final questions here.
Yeah, go ahead.
First of all, I want to say that your approach makes a lot of sense to me. I thought it was fascinating and interesting.
Thank you.
The only question that I have was about the particularity requirement when you talk about using customer service hours. That seems pretty arbitrary. You know, if you pick 500 hours because, you know, you're using the bank for all of it. I'm thinking that if I were a police officer or doing an investigation, having any kind of any arbitrary customer service hours wouldn't necessarily be that.
You're right that it's arbitrary, and the thought is that some arbitrary line is better than no line at all. That's basically what I'm concerned with. So right now, I hear stories from friends that are working at providers or working in law enforcement of police officers that'll say, okay, here are 500 accounts. I want all the records for the 500 accounts. And so it may be that 500 customer hours is arbitrary compared to that, but it's arbitrary compared to essentially an unlimited current regime. So just some limitation is needed, and I think the customer hours idea is better than other alternatives. Yeah.
To what extent do you envision an operator terms of service renewal impacting the rules?
Yeah, I don't see them impacting the rules. There's some questions as to whether terms of service generate consent under these statutes, the consent to release information. And I think that the better reading under the current consent standard is that they do not, which I think makes a lot of sense because people don't actually read terms of service. So it'd be bad if they actually had some significance. And even lawyers, even I tried to read them, I have no idea what they mean. So if I can't figure it out, I kind of assume most people can't. So I would not rely on those in general.
Well, again, I want to thank you all for coming to the 7th Annual John Gedid Lecture. We have a reception that is following immediately this event over in the reception room. If you just follow the crowd, those of you who don't know where that room is, you will find it. And I believe you're staying by for a little bit. You
Yeah,
can come to
reception, sure.
If you have other questions for the Professor. I'm sure you entertained them. Thank you for coming.
Thank you.